first case to come before the court today is State of Ohio versus Theodore Palmer. Each party will have 15 minutes to present their arguments. Appellant may reserve up to 5 minutes if you wish to do so. Let me know when you take the podium. I'll do my best to keep you apprised of the time. The arguments are being visually and audibly recorded to be posted online, so please keep your voices up and remain behind the podium. It's not an issue in this case, but just for the next 3 cases, if any victims or children are involved, please don't use their names, just use initials or some other way of designation. And we've read your briefs and we're ready to proceed when you are.
Good morning, Your Honors. Eric Hall on behalf of the appellant Theodore Palmer. In this case, the appellant was charged with aggravated trafficking drugs with a specification that occurred within the vicinity of the juvenile. Either the juvenile was present or at the time or the juvenile observed the transaction. As a result of that specification required mandatory time. The appellant is now serving a 6-year prison sentence as a result of conviction. I raised 2 assignments of error in the brief, Your Honor. Sufficiency of the evidence and manifest weight. Particularly, I want to draw the court to the issue of the specification within the vicinity of the juvenile. In the trial, there was no evidence presented in the trial that this alleged transaction took place within the vicinity of a juvenile. It took place in
counsel. How much time did you want for rebuttal?
Oh, I'm sorry, Your Honor. 5 minutes, Your Honor.
I'm glad you didn't tell me. I was afraid you told me and I forgot.
No, Your Honor, I forgot. I'm sorry. Thank you, Your Honor.
Sure.
This took place at General Store. The Medina App.No Drug Task Force was involved in this. So this was a controlled buy, controlled sale. None of the state's witnesses who testified at this trial were inside that store at the time that this transaction occurred. So because of that, nobody would know whether or not a juvenile could testify, whether a juvenile was present in the store itself. There was no video. Nobody observed, no agents were in the store. One agent testified, it was Agent Stable, that he believed that he saw a juvenile in the parking lot, okay, which arguably could have been within the vicinity. However, this juvenile was never identified and did not testify in the trial. So based upon that, I'd like to draw the court's attention to State versus Weaver, which I believe is analogous. And actually the facts and circumstances in this case, I think, are even better than the facts in Weaver. The facts in Weaver were that there was a drug transaction took place inside a hotel. In that case, I believe there was a juvenile who was outside of the parking lot. Because the juvenile was in the parking lot, the transaction took place in the hotel, the court reversed that conviction based on the specification and remanded it for resentencing because the state failed to present sufficient evidence that the transaction occurred within the vicinity of the juvenile or that the juvenile observed that.
Counsel, is there in the record video surveillance of the outside of the Chatham store at the time that the folks were there in the parking lot and in the store?
My understanding, Your Honor, that there was no video in this, and there was no video. Also, and my argument goes to the manifest weight also, that basically, if you go down the list, there were no agents witnessed any juveniles. There were no other witnesses that testified in trial who could have testified. Yes, there was somebody there who I believe was a juvenile without confirming their age. That didn't happen in the trial.
Is there any indication in the testimony of the officer who believed he saw a juvenile, that the juvenile was sitting in the driver's seat or the passenger seat of the car?
They were in a black vehicle, and they believed them to be under the age of 18. But that's a pretty close one, Your Honor, because...
Was there testimony about where inside the car the juvenile was seated?
I believe that they were seated in the car. I'm sorry, Your Honor.
It might not be in the record. That's the question. So it's okay. We'll take a look.
I'm not sure that it is, Your Honor. I know it's in the record that they were in the car and that the car was a black car. And also it's clear from the record that this person was never identified, and it's pretty clear from the record that they never testified in the trial, which, of course, it states the pollster state's position if that person was in fact a juvenile and they were identified, or if they did testify in trial, then arguably that would have been sufficient evidence so far to convict the appellant with the specification. It just didn't happen. The other argument I have, and just briefly, is that in this case, they failed to prove basically that there was actually a sale. I mean, once again, there was money exchanged, but there was testimony that this money was, that there was a loan involved, that the appellant had some kind of a prior personal business dealing with Ms. Berry. And that's the basis, that there wasn't any drugs involved, and Ms. Berry was actually doing this in cooperation with the Medina App.No Drug Task Force to do what they usually do, was to work off her own case in this case. They have somebody go out, and in order to work off your case or to get a better deal or even get the case dismissed, you have to go out there and find somebody, okay, to sell drugs to. The task force does not help you do that. You have to do it on your own. In this case, with the appellant, she went out and she picked somebody simply that she knew, she was acquainted with, and set them up basically to work off her own case. Unfortunately, Ms. Berry passed away, okay, and that's unfortunate in this case, rather. But I would ask the court to look closely at this and look closely at the State versus Weaver. I believe that not only is it analogous, this is the facts in this case are even better for the appellant regarding this case, because in Weaver, there was a juvenile. It's clear from the record and the decision there was a juvenile, but the juvenile, because the juvenile was in the parking lot and the transaction took place inside the hotel, that court, which is the District Court of Appeals, found that was insufficient evidence to find out that the conviction, or that the evidence supported that the transaction took place within the vicinity of the juvenile grounds.
Counsel, I believe the state's, part of the state's argument is that Mr. Palmer confessed to the sale twice.
On the actual conviction for the sale?
Right.
It's, briefly, Your Honor, this was a case which went to trial, and the appellant denied all the charges, all the elements of the charge. I raised it in the brief, Your Honor. I still believe, under the circumstances, based on history that the appellant had with Ms. Berry, that there certainly was some reasonable doubt in this case as to what happened.
Did Mr. Palmer explain at all what he meant when he asked that? But I believe it was an audio recording. Is there anything in the record that would explain his statement? Do you have the money for that?
Well, my understanding was there was a loan. There was some kind of prior business dealings, personal business dealings for, I believe it was for rent of an apartment or some other things. And I believe that could have been what the appellant was referring to. Do you have the money for that? I mean, if, I'm getting an apartment or I'm doing this, there's prior loan. Do you have the money to do that? Okay, without an actual witness to what happened in the actual transaction, I would say that certainly raises the issue of reasonable doubt or sufficiency of evidence on conviction. But I really want to draw the board's attention mostly to the issue of whether this occurred within the vicinity of the juvenile, because it significantly affects the sentence that the appellant received in this case, Your Honor. In terms of any other questions?
Okay.
Thank you, Your Honor.
Morning, Your Honors. May it please the Court, I'm Vince Felucci, Medina County Prosecutor's Office for the appellee, the State of Ohio. So the sufficiency argument, there's, in the assignment of error 1, there's two distinct arguments. The 100 feet of a juvenile, within 100 feet of a juvenile, that's the where Mr. Paul was sort of focusing. I'll start with that. Agent Stayrook's testimony was that the Palmer and the confidential source were seen entering this Chatham General Store, and that's where we know the drug transaction took place for several reasons, but which I'll get to. But the video shows a vehicle close by in the parking lot where a juvenile female is seen sitting in the passenger seat. To answer Judge Hensel's question, Agent Stayrook testified that the juvenile was definitely within 100 feet of Palmer when the transaction took place, and that's the test for that specification, within the vicinity of the juvenile. And that's what the testimony was.
You're saying that the 100 feet counted the transaction being in the store? That's
Correct.
What you're referring to as a transaction? Okay.
Yes, this is not a big place, big establishment. The parking lot, parking space was fairly close to the inside of the store, is my understanding. Just to address a couple of Palmer's claims here, the state did not have to prove that the juvenile was actually inside the store when this transaction happened. Certainly, it's 100 feet. It doesn't matter if they're indoors, outdoors, wherever. The state did not have to have the juvenile actually testify at trial. There's nothing that says the state needed that to have sufficient evidence. The state did not have to identify the juvenile. The state did not have to provide the juvenile's date of birth. There's no cases saying that we need that.
But how did the state show that this female in the passenger seat was juvenile? I mean, for instance, if it was a female baby in a car seat, that might be readily apparent. I assume that's not the case, but what was the evidence in that regard?
It was Agent Stayrook's testimony that it was clearly a juvenile and it was clearly within 100 feet, and that is sufficient.
And you said that there was a video of that also?
There was.
Submitted in evidence?
I believe the video was played, Your Honor, but again, I don't think that was necessary either to necessarily play that video. I think Agent Stayrook's testimony by itself would be sufficient, and the jury chose to credit that. There's no requirement that the state of Ohio do all those things that Palmer is claiming. And he does focus on the Weaver case, but the Weaver case is very much distinguishable from this case out of the 8th District. In that case, both the witnesses who testified about the juvenile said they found out about the juvenile from someone else, secondhand, and neither one testified that they actually saw the juvenile at the scene in that case. We have an agent of the Drug Task Force saying that they actually saw the juvenile at the scene in this case. In Weaver, there was also no actual specific testimony that the juvenile was within 100 feet of the transaction, which that's the test, that's the element, and there was no testimony to that. That's why in Weaver, the 8th District found that the evidence was insufficient to support that element. There was just no testimony. And
Well, counsel, since we're talking in the second assignment of error anyway, manifest weight, let's move away a little bit from the Weaver case since it's more sufficiency, right? How does it shake out if you indicated the video was played? What if it was played, not admitted, so we don't have it, but there could have been a doubt situation as it relates to the jury having seen what the officer was referring to as a juvenile at the time?
well, there could have been, but there wasn't in this case. And they had the opportunity to see Agent Stayrook testify and observe his testimony, and that's important, I think, and also to just consider the whole context here of the case and of his testimony, and they have the chance to judge his credibility, I think, and they have the right to believe him, not believe him, and they apparently believed him in this case.
Was there this argument at trial regarding the designation as this person in the car being a juvenile?
There was some, but I think that was just one part. There was the other elements as well, and I would also point out there's another case that's cited, the Walker case out of the 3rd District, and in that case, that's also distinguishable from what we have here, because the drugs in that case were actually in police control when the juvenile was within 100 feet of them. The actual transaction did not take place within 100 feet. So that's also different. And the court in that case said it was insufficient for the vicinity of the juvenile. Again, we don't have that situation here. The drugs were not in police custody here until the confidential source came back to the car, and she handed over the drugs, and ultimately they tested positive for methamphetamine. So again, a big difference there. In terms of Palmer's, I'll move to the knowingly sell or offer to sell methamphetamine. Both happened in this case. There was an offer that occurred before the transaction took place. This was as Mr. Hall mentioned, a controlled buy with the Medina County Drug Task Force. It started like most of these buys do. The source contacted Agent Caraballo, said she'd been in contact with Palmer, who she had done drug deals with before. And Palmer made a very specific deal with her that she could buy 7 grams of methamphetamine for $275. That they had it all worked out. They decided they'd meet and do the deal at the Chatham General Store, and that's exactly what happened. The source was driven actually by an undercover drug task force agent to the scene. The source was wired with a microphone. She was given $275 of buy money from the task force. There was also some pre-buy surveillance done on Mr. Palmer, and Palmer was seen stopping at a barn that he owns for about 30 minutes, right as he was on the way to the meet. As was mentioned, the source and Mr. Palmer walk into the general store together, and Mr. Palmer is heard on the microphone clearly saying, "Do you have the money for that?" And I think the jury was permitted to use their reason and common sense to make a decision about that,
Counsel,
what that means.
I have 2 questions. Again, as to the manifest weight, there's a deal for what he'll give her for $275. She ends up giving him $225, $50 short. Is there an indication that she got the amount of drugs that the alleged deal was?
The $225, I'm not sure. There's evidence in the record that is what she gave him.
Okay.
The source didn't actually testify at trial. She had passed away by the time of trial. What was found in Mr. Palmer's car when he was pulled over was $225. So he may have done something with the other 50. I'm not sure. It just wasn't recovered. I'm not sure if that's. But she was given $275. I don't think it's clear in the record why there's only $225 in his car, but I don't think that really matters for the analysis all that much. A lot of things could have happened to that other 50, I guess. But the point is, there's meth found. There's this meeting inside the store. There's minutes later meth found on her, and the money that the drug task force gave her on him in his possession. So there was an exchange of drugs for money that took place.
How about the argument that the meth was in her purse? Did she go into the store without a purse and come back with a purse with meth in it? Come back out of the store with a purse?
The drug task force certainly searches the source beforehand to make sure there's no drugs going into the transaction. That's very important that they do that. They go through their whole, and there's a lot of testimony about their whole routine that they go through when they meet with the source. So yeah, they confirmed she did not have anything on her.
No purse?
Going in there. That she did not have methamphetamine in her purse.
Okay. The question is, because I believe the testimony, there's some indication from the brief anyway, the testimony is, or there's some indication that she left her purse at Mr. Palmer's house, and he was returning it to her. That purse contained methamphetamine. So the question is, did she come out with it? Let's forget about the methamphetamine. Did she come out with a purse that she didn't have when she went in?
That's correct. There was no. She did not have the purse on her. I think that's correct. And she there was no methamphetamine on her. There was no purse on her, I believe. And I'm trying to think. No, I think that's his. I think that's his story. But I don't think that's made abundantly clear in the record in terms of did she walk in with a purse or not. So he admits, that's the other part of this, there's 2 admissions by him that a drug transaction took place. He He admitted that he sold a quarter ounce to the source for $2.75. That's what he says. So there was that. He even explained that it had been difficult for him living off his retirement. He explained that he was supplementing his income by selling drugs. He admitted that he's also into cocaine, that he would purchase powder cocaine and he'll make crack cocaine if his customers want it. The task force got his consent to search his home in the barn. And in the barn is where the overbulk amount of meth and several grams of cocaine were found, and that's obviously significant when you consider he stopped there right 30 minutes before the deal took place. There was also a jail call that from the day of trial that Agent Caraballo testified about, where Palmer is actually he's out of jail and talking to an inmate in jail, and he says, "I was just giving her back her meth." So he does admit that he gave on tape admits that he gave her methamphetamine. And knowingly did that. So I don't think it ultimately matters when you talk about is he handing her a purse or just methamphetamine without a purse. It's still a trafficking violation. I don't think that matters one bit legally in terms of a trafficking taking place. In terms of actually eyewitnessing the transaction, the task force didn't need to actually have somebody in the store watching this transaction. I think a microphone is pretty good. It's like being there when you hear him talking about, do you have the money for that? We know that circumstantial evidence is just as probative as direct evidence, sometimes even more so. When you look at all the evidence in this case, there's overwhelming evidence that Palmer both knowingly sold and offered to sell methamphetamine. In terms of manifest weight, I would just say there were 6 credible witnesses that testified for the state, and Palmer had his arguments, basically, that he didn't put on a case. And the jury chose to believe those 6 witnesses, as was their right to do. Again, I'll just summarize. We had 2 confessions on 2 different occasions by Palmer in this case that he sold the drugs. We've got a prearranged buy with a confidential source with terms clearly stated. We've got an exchange of cash for drugs that takes place on tape. And then we've got more drugs found in Palmer's barn where he stopped just before the meet. So given all of that, I would submit that the evidence weighed heavily in favor of Palmer's convictions.
Can I ask you a question? I noticed in your brief states that, yes, Agent Steyrick's testimony could also reasonably support the conclusion that the drug transaction took place within the view of a juvenile, but you're not arguing that today. You're saying it was within 100 feet of the juvenile, not within the view of the juvenile.
Both. I think both. I think either one.
Front on the store, and the child could see inside the store.
I think that's plausible as well. But I think I'm not saying that there's no way that can be possible. But the main thing is it's 100 feet for sure, and that was the clear testimony of Agent Steyrick. He didn't actually testify. I know it was within the view of this juvenile. That you'd more have to establish, I think, probably through the juvenile's own testimony. But
Hang on for a second. You feel a question?
Yes.
am I out of time? Okay.
She got you right at 1 second, so, okay.
Thank you, Your Honors. I would just
You're
ask that
welcome.
the trial court be affirmed.
That's okay. Mr. Hall, you have your full 5 minutes, should you wish to take it.
Thank you, Your Honors. I'd like to point out that this case could establish a really troubling precedent. This is an essential element to simply allow somebody from law enforcement to come in and testify that there was a juvenile in the parking lot or the vicinity of a drug transaction because they believe it was a juvenile. Okay? And not identifying that person, not making the determination that they're in fact a juvenile, because 18 years old, it's a pretty close call. They, 1 month shy of 18, they're a juvenile. 1 month past 18 and over, they're an adult. So that's not the essential element of this charge, and this would have resulted in a different sentence for Mr. Paul. Words like believe and probable, we should not convict people in this country on those words. There needs to be a higher level of proof, especially with this specification, which is an essential element. There's nothing in this jury essentially lost its way because it gave undue weight to the testimony of this officer. The fact that he was convicted, Mr. Paul, the appellant was convicted of conducting a drug transaction, the jury at that point then lost their weight with the other element of the charge, which was whether or not this occurred within the vicinity of a juvenile, I believe probably, because there seems to be some evidence or enough evidence that they could have reached a decision that he did conduct the transaction. That is the point where they lost their way, and they believe because of that, then he must have conducted it within the vicinity of a juvenile because the officer said so. He believed. That's not sufficient, Your Honor. It's not sufficient. It's an essential element, and the state should be required to put on evidence to prove that element. They could have done it. They could have done it. They could have went over and talked to this juvenile. They could have asked for her identification, They could have found out who they were, they could have brought them to court. Without that, this element fails, Your Honor. And this case this conviction should be reversed and remanded back for at least for resentencing on that issue, because it involves significant time and loss of freedom for the appellant. Thank you, Your Honors.
Thank you. All right, thank you both for your presentations. The court will take the matter under advisement, issue written decision, which will be mailed to both sides as well as posted on our website and the website of the Supreme